I remember a case that happened several years ago in the news. It was reported that the actress Winona Ryder had been caught shoplifting at some store in Hollywood. And the outcome of the case wasn't that she was sentenced to jail time or ordered to pay compensation to the stores she stole from. It was that she was sentenced to undergo therapy, to seek counseling for a mental disorder called kleptomania, which is a name for a strong compulsion to steal. And that case illustrates something we talked about in the first lecture of this course, which is that in addition to this kind of variation that we can think of as quantity of law, how much legal authority gets involved in the case, how far the case proceeds through the legal system, and how much use of law you get in a community or a family or whatever. In addition to that kind of variation, we can also look at variation in the kind of sanctions that a legal case results in. The same type of offense, the same type of deviance, might be conceptualized and handled in very different ways. Theft might be treated as a matter of a debt to be paid, and the way to handle the case is to make the offender pay back what was owed to the person who suffered the loss. Or it might be treated as a crime to be punished, and so the offender is sentenced to something like jail time, or maybe in an earlier period of history to flogging or public shaming. Or it could be something like the Hollywood case with the actress, where someone is sentenced to be counseled and undergo a therapeutic process designed to help them become normal and get over whatever issue led them to commit the crime. We can understand this variation in outcome with a concept called the style of law. And this is something that is outlined in the first chapter of The Behavior of Law, if you want to go consult that reading again. The style of law is the language and logic by which a case is handled. How do we conceive of this deviance, and what is the appropriate way of handling it? Black identifies 4 different styles of law, which can be grouped into 2 categories. The first group are accusatory styles of law. And these are styles of law that's more of a one person against another type of case. This is something that's consistent with more authoritative settlement that's more one-sided, where you're looking to decide whether one party's in the right or one party's in the wrong. And accusatory styles include the penal style, which is typical of modern criminal courts. In the penal style of law, the deviant is defined as somebody who's violated a prohibition. So we have rules prohibiting certain conduct, whether it's stealing or assaulting somebody or killing somebody or using certain kinds of drugs or whatever. And this offender has violated these rules, and because of that, they need to be punished. That's the logic of the penal style of law and the logic of criminal law in the modern U.S. We have another accusatory style, the compensatory style, and this is typical of American civil courts. The courts you go to if you want to file a lawsuit against somebody rather than, say, call the cops on them. In the compensatory style, the deviant is defined as a debtor, as somebody who has incurred an obligation and owes you something. It might be because you had a contract and they reneged on their side of the deal. You paid them and they didn't do the thing they were supposed to do. It might be because they failed to fulfill some other kind of obligation, like, maybe the shopkeeper didn't clean the ice off the sidewalk in the front of his shop, and you slipped on the ice and you fell down, and it was his responsibility to clean that ice up so people wouldn't fall, and he failed at that, and now he's obligated to pay for your medical bills. You wouldn't have those medical bills if he didn't fail to fulfill his duties. So the deviant here is seen as somebody who's incurred a debt, and they owe somebody else compensation, and so they have to pay damages. Remedial styles of law, unlike accusatory styles, are more focused on social repair. This is something that's consistent with less authoritative settlement, with cases that are not being handled in a one-sided matter where, one party's right and one party's wrong. In remedial styles, it's more of like you're trying to help both parties. You might even be trying to help the deviant. And so you do get this in modern courts of law, and you do get it in modern policing, but it's more typical of the law of small-scale societies, village settings, places where people are very intimate and familiar with each other. One remedial style is the conciliatory style. And in this style, rather than finding one party as deviant and the other as the victim, Both parties are seen as disputants. They're people who have a conflict, they have a dispute with each other, and the focus of the case is on bringing harmony back to their relationship. There's been some disruption in the relationship of these two disputants, and we need to restore harmony. And in the therapeutic style, the deviant is defined as a victim of forces beyond his or her control. And we can see this in cases where somebody is remanded to therapy because they're defined as having a mental disorder that caused them to violate the rules. So in the therapeutic style, the problem is that the deviant is abnormal and they're a victim of some sort of disorder, and they need help to return to normality. And if you return them to normality, the deviance will cease. And in modern societies, we think of this in terms of psychiatric problems and try to solve it with things like counseling and medication. Maybe in other times and places, they view this in more supernatural terms and would say the person's suffering from spiritual possession or a curse or something like that. And maybe they'd bring in some ritual specialist to pray over them or do magic or something like that. But the core logic's the same. You're treating the deviant as somebody who is not being deviant through their own choice, but needs help to avoid being deviant. Just like with the overall quantity of law, we can explain the style of law with the social structure of the case. One idea from the behavior of law is that accusatory styles increase with social distance, and remedial styles decrease with social distance. So accusatory law varies directly with relational and cultural distance, and remedial law varies inversely with relational and cultural distance, meaning cases between people who are very close, such as friends and family, are people from the same cultural group, the same subculture, the same church, the same whatever, are more likely to handle their conflicts in a remedial way than are people who are strangers to each other and from different cultural groups. And like all the other relationships we talk about, this could happen through several mechanisms. It could be mostly a bottom-up thing where people naturally tend to be more sympathetic towards those close to themselves and similar to themselves. And so they're more likely to define the deviance in a sympathetic way. It's not really his fault. He's just been under a lot of stress. He's depressed. He's got some mental issues. Or it could be more of a top-down thing where legal officials themselves are inclined to define things this way and say, okay, well, this domestic violence, this is really just a family issue, and the key here is to try to make peace between the members of the family, and that'll settle the problem. And maybe the members of the family actually are trying to be more accusatory, but the state officials aren't going along with it. In any case, so this is the relationship you appear to get. Penal and compensatory law are more likely between more distant parties, and conciliatory and therapeutic law are more likely between close parties. So people who victimize strangers are more likely to be defined as criminals in need of punishment, and people who victimize close relatives are more likely to be defined as suffering from insanity of some kind. And disputes between people who are distant from one another are more likely to result in lawsuits seeking damages, whereas disputes between people who are closer are more likely to result in some attempt to make peace between them without a formal damage award. So downward law is more penal than upward law. Those who victimize social superiors are more likely to be punished than those who victimize social inferiors. Vice versa, upward law is more compensatory than downward law, meaning cases where someone's been victimized by a social superior are more likely to result in compensation or demands for compensation than cases where someone's victimized by a social inferior. And you can see this in the relationships between individuals and corporations. Corporations that rip off their customers or cause them some harm are relatively unlikely to be prosecuted in criminal courts. In fact, you could say that organizations are almost immune from criminal law unless they violate some sort of federal law. Instead, usually what happens is if the deviance is severe enough, people will sue the corporation demanding compensation, including things like class action suits where you have thousands of people named as plaintiffs in a lawsuit against some corporation that's supposedly wronged all of them. On the other hand, when an individual wrongs a corporation, say steals from it, they're unlikely to be sued for compensation, and they're more likely to have the police called on them and charges filed, and for the case to be handled in a penal manner. Another relationship is that therapy varies directly with the social status of the offender. And this is something we could see in cases of Hollywood celebrities and whatnot, whose deviance is handled with counseling and therapy. Finally, note that you get some kinds of law that are more likely between equals than they are in either a downward or upward direction. So lateral law between people who are roughly equal, is more conciliatory than either upward or downward law. So efforts at conciliation are greatest when the parties are relatively equal than if they're unequal. And this is something that can be seen clearly in studies of police behavior, like the facts that came out of that large-scale tri-state police study. So police actually do a lot of informal dispute settlement at the scene of disturbances. They don't just arrest or not arrest, they might handle the case in other ways, encouraging the parties to talk things out and shake hands and make peace and so forth. And observational studies of real police behavior in the field reveal that they do this more often when the parties are similar in status. So in cases where they get called to the scene of a dispute and the parties are of similar status, the same social class and education, maybe they're a married couple where both sides work jobs and have a claim on ownership of the house or the apartment, they tend to handle things in a more conciliatory manner, maybe even spending quite a bit of time at the scene, encouraging the parties to talk things out and hoping, they put their differences behind them and they never get called to that place again. When the parties are unequal, they're more likely to either make an arrest or do nothing at all.